Most custody cases in Arkansas are won or lost on behavior, not the law. Arkansas law gives judges broad discretion to decide what is in the best interest of the child. And here are 5 mistakes that repeatedly push good parents to the losing side. In Arkansas, every custody case turns on one question: what is in the best interest of this child? That phrase, best interest of the child, appears throughout Arkansas custody law, which governs child custody and visitation. Judges look at things like the child's physical safety, emotional stability, school performance, home environment, the willingness of each parent to support a healthy relationship with the other parent. Arkansas law now presumes that joint custody is favored when it's in the best interest of the child, meaning an approximately equal division of time with both parents unless there's a clear evidence that joint custody would harm the child. Now, with that framework, parents can still lose ground because of avoidable choices. My name is Leon Jones Jr., and for over 15 years, I've practiced in both state and federal courts here in Arkansas. I've also worked for a Fortune 100 company and held positions as the director of the Arkansas Department of Labor, as well as the executive director of the Arkansas Fair Housing Commission. Now, I'm the managing attorney here at Big Rock Legacy Law Group, where we represent and advise clients in business law, civil litigation, estate planning, and family law. Over these many years, I've had families deal with this very issue, and I hope this video provides some insight into how I provide my advice, which is different for every family. So here are the 5 crucial mistakes people make in Arkansas custody cases, and how can you avoid them? Mistake number 1, ignoring the best interest standard. The first mistake is treating the custody case as a fight to win against the other parent instead of a process to protect the child's best interest. Arkansas courts are required to center their decisions on what arrangement will best serve the child's health, safety, and overall well-being, not which parent is more deserving or more offended. Judges routinely consider factors such as the child's physical safety and emotional stability in each home, the stability of each parent's home, work schedule, and their caregiving history, the child's relationship with their siblings, extended family, community, which includes their school, churches, and activities. And the courts also consider any history of domestic violence, substance abuse, or neglect, even if the child didn't witness the abuse or have the abuse on them directly. Thinking like a litigant instead of a parent leads to bad decisions, like turning every issue into a power struggle or focusing on fights instead of the child's day-to-day life. Parents who do better document how they meet the child's needs, school involvement, medical appointments, and routines. They show flexibility, stability, and a child-centered mindset in their testimony and the court conduct outside. When you align your behavior with the best interest factors judges actually use, you stop working against the very standard that will decide your case. Mistake number 2, disrespecting court orders and the other parent. The second crucial mistake is disrespecting either the court's orders or the other parent's role in that child's life. These are often treated as emotional issues, but in Arkansas, they become legal problems very quickly. Arkansas law entitles a parent who is not awarded primary or joint custody to reasonable parenting time unless the court finds that the parenting time would seriously endanger the child's physical, mental, or emotional health and well-being. Judges can and do react strongly when parents, 1, deny or interfere with the other parent's court-ordered time without legitimate safety reasons, 2, regularly show up late, miss exchanges, or forget to follow the schedule, 3, violate specific provisions of the order like travel restrictions or requirements to share information. Repeated violations can lead to findings of contempt, sanctions, and other changes in custody if the judges see a pattern or willingness to create conflict or disrupting joint custody. Disrespect also shows up in how parents talk to each other. Arkansas courts look at each parent's willingness to foster a relationship between the child and the other parent because the cooperation supports the child's emotional and physical health. Now, when you badmouth the other parent in front of the child, use the child as a messenger or a spy, refuse to communicate basic information about school, health, or other activities, you not only hurt the child, you signal to the judge that you may not be able to support a joint custodial arrangement or a generous visitation arrangement. Parents who help themselves do these following things. One, they follow the court order exactly, even when they disagree with it, while pursuing proper legal channels to change it. Two, keep communications with the other parent businesslike, brief, and child focused. Now, to learn more about how we assist our clients with these and other types of legal situations, please click below and let's get started today. Mistake number 3, failing to document and communicate the right way. The third mistake is failing to create and preserve a clear record of what is happening in your child's life and failing to communicate about it in a way that shows you can share joint custody. Arkansas courts often start with the presumption in favor of joint custody when it is in the best interest of the children, especially when both parents can communicate and they're willing to cooperate. Judges look at factors whether A, the parents can share important information on school and medical care, counseling, and activities. 2, make major decisions together, or at least give the other parent a meaningful chance to participate. 3, keep the other parent informed about changes in addresses, phone numbers, and emergency contacts as required by any court orders or just basic common sense. Now, common documentation mistakes include relying on memory instead of keeping a calendar and actually parenting time, no-shows and important events, not saving texts, emails, school reports, and medical records that support claims about involvement or concerns, communicating in anger, insulting messages that later get read by a judge in a very different tone. Now, parents who strengthen their position keep a simple log of parenting time, exchanges, and important incidents with dates and short notes, communicate in writing when appropriate, assuming every message may one day be read in court, share school and medical information promptly so the judge sees a pattern of cooperation and not control. By documenting carefully and communicating respectfully, you provide the court with the objective evidence and you show that you're capable of effective joint legal custody. Mistake number 4, overlooking safety, domestic violence, and substance abuse. The fourth crucial mistake happens on both sides of the courtroom. Some parents exaggerate minor issues, while others downplay very serious safety concerns involving domestic violence or substance abuse. Arkansas law specifically requires courts to consider domestic violence when deciding custody and visitation, including the effect of the abuse, even when the child did not see it or did not suffer directly from the physical injury. When there's a proven history of domestic violence, courts must place primary importance on the safety of the child and of the abused parent. Judges may respond by 1, limiting or supervising parenting time for the abusive parent, 2, restricting overnight visits or ordering conditions like sobriety, counseling, completion of a battered intervention program, 3, declining to enter into joint custody in these situations. The mistake victims often make is failing to present clear evidence, such as police reports, protective orders, medical reports, photographs, or witness statements. Now, on the other side, parents sometimes weaponize accusations, making claims they can't prove or stretching the facts. Judges may see many custody cases and are trained to look for collaboration, corroboration, patterns, and credibility. Inconsistent or exaggerated allegations can damage credibility and backfire. Parents who approach safety issues wisely, take real threats seriously, use legal tools like orders of protection, and document everything. They follow through with counseling, treatment, or other conditions if the court requires them, showing change and responsibility. They avoid making unfounded or petty accusations that distract from the child-focused issues the judges have to decide. When you treat safety as a legal threat, serious, evidence-based, and focused on the child, you protect your case and you protect the child. Mistake number 5, treating custody as a one-time battle instead of an ongoing legal relationship. The 5th mistake is thinking of custody as just a one-time or one-and-done verdict instead of an ongoing legal relationship that can change with behavior and the child's need. In Arkansas, custody orders can be modified when there has been a material change in circumstances and a change which serve the best interest of the child. Examples of these changes may include significant changes in a parent's work schedule, living situation, ability to care for the child, the ongoing failure to follow current orders, including chronic interference with visitation, new safety concerns such as substance abuse, criminal charges, or new incidents of domestic violence. Now, parents hurt themselves when they, number one, give up after an initial unfavorable order and stop exercising parenting time that they do have. When they make informal side deals that contradict the written order, then have no clear baseline with the other parent and they change their mind, and failure to seek modification when changes are necessary. Parents who protect themselves in a long-term position treat current orders as the floor, not the ceiling. They use every minute of ordered time to build a consistent track record of involvement. They keep records that show how the child is doing in their care, which is school, health, routines. So if modification becomes appropriate, there's evidence to support it. And they work through their attorneys and the court system to make sure changes are made instead of relying on secondhand or secondary agreements. When you view custody as an ongoing legal and parenting relationship, you think more strategically and stay focused on the child's development over years, not just the outcome from one hearing. The same 5 mistakes that destroy custody cases can become a roadmap for doing better. Parents in Arkansas put themselves in a stronger position when they, number one, line up their behavior with the best interests of the child, which are factors the law uses. Number two, respect court orders and the other parent's role, even when it is emotionally difficult. Number three, communicate and document like they expected a judge to read everything later. Number four, when they handle safety issues, including domestic violence and substance abuse, with honesty, evidence, and seriousness. And number five, when they remember that custody can change and that child-centered behavior over time carries weight with Arkansas courts. When parents avoid these 5 crucial mistakes, they not only strengthen their legal case, they give their children their stability, safety, and support Arkansas's custody laws are designed to protect. The stakes underscore the need for professional guidance and coordinated planning with an experienced attorney. I encourage each of you to evaluate your situation early and discuss your unique needs with qualified professionals to secure the best possible outlines. Make sure to subscribe to our channel to learn more valuable information about how we here at Big Rock Legacy Law Group protect your legacy and advocate for your rights.